Ladies and gentlemen, welcome back. My name is Kathy. This week, on November 14th, there are two crucial deadlines that could shape the rest of the case and possibly even give Mr. Kohberger grounds for a motion to dismiss the entire case against him. They are the November 14th deadlines for motions to compel discovery, anything that is related to discovery, any discovery-related motion that has not already been filed. And secondly, any motions having to do with Idaho Criminal Code Rule 12 that deals with pretrial motions, defenses, and objections. And the one thing that is listed specifically in the pretrial order is motion to suppress. Suppress what? Suppress evidence. Suppress evidence from ever getting before the jury. What might they be? Well, the true crime community has been talking about the possibility of having the IgG DNA evidence thrown out, or evidence that Mr. Kohberger was the alleged driver of suspect vehicle 1, or evidence related to his phone records, or evidence that we don't even know about because the majority of the requests for production of that evidence and responses are all under seal. So there may be even other requests to suppress evidence that we don't even know about. In any event, the absolute last call for those motions, November 14th, 2024. Now, what's the relationship between both? Well, you request discovery, that's possible evidence. If it's not turned over, you file a motion to compel, which is heard by the court. It's either granted or not granted. If it's granted, then you think that there's grounds to suppress it, to keep it out of the trial, you file a motion to suppress. If a motion to suppress is granted, let's just say on the IgG evidence, and somehow at trial next year, which by the way begins July 30th, not in August, because that's when the process of voir dire starts, it doesn't get before the jury. And if someone mentions it, let's just say the state accidentally talks about IgG, or a witness for the state talks about IgG, defense could stand up right there and say, a motion for mistrial, judge. The jury is then let out of the courtroom, and the defense counsel says, hey, judge, you granted us a motion to suppress this evidence, and now they're talking about something that should never get in the case. My client's entitled to a mistrial because the jury now is tainted, and no instruction that you can give them could get them to not unhear or not unsee what they've seen or heard. Secondly, if there is enough evidence that's suppressed, where the defense has a good faith belief based on legal authority that they cite to that there is not enough here to get this to go to trial, well, what's the potential then if the judge agrees? If the judge agrees, motion to dismiss granted, there's not even a trial in this case. Or the state could argue, well, judge, that's a jury question. That's a jury question if there's enough here to get to a jury to either decide whether or not Mr. Kohberger is guilty or not guilty beyond a reasonable doubt, and that is an evidentiary standard. Beyond a reasonable doubt means beyond a reasonable doubt based on the evidence that is brought forward in the case and presented to the jury. We are covering the Idaho 4 case and have been. We, on the IndieZone Podcast, which is available on multiple platforms, we will continue to watch and monitor the docket and report back in 5-minute or less episodes what is on that docket. Thank you very much for joining us.